Qualifications. If a lay witness is invited to offer an expert opinion about a particular matter, object on the grounds that the witness is not qualified to offer expert opinions. Lay witnesses are not experts by definition. Expert witnesses, on the other hand, must be qualified by the court by court approval. Then, and only then, can their opinion be offered. Lay witness opinions are permitted as to matters based on personal knowledge and observation of the lay witness, where, according to the United States Supreme Court, they are rationally based on perception and helpful to a determination of the facts in issue. Lloyd versus American Airlines, 537 U.S. 974 in 2002 was the year of the case. Thus, a lay witness may be qualified by showing that he or she has personally perceived what they are called upon to testify, and what they can offer will be helpful to a determination of a fact in issue. Expert opinions, on the other hand, cannot be obtained from lay witnesses. Experts can only testify as experts if they are offered as experts and subsequently qualified as experts by the court. After both sides have an opportunity to voir dire the expert as to his or her qualifications. If opposing counsel offers an expert witness, object before questioning begins. Move the court for an order allowing you an opportunity to examine the witness outside the hearing of the jury to determine if the witness is qualified to testify as an expert. If the court finds the witness is qualified to testify as an expert, object and renew your objection at the close of your opponent's presentation to preserve your objection unless it's clear the witness does have the requisite qualifications to testify as to the questions asked, in which case your objection will probably be to no avail. If opposing counsel begins questioning an expert witness about matters outside his or her qualifications, object. And if the judge overrules you, renew your objection at the close of your opponent's questioning, and again at the close of his presentation. Expert opinions should not be permitted from witnesses who have not first been qualified by the court and designated as expert witnesses. A lay witness, on the other hand, unless he or she has first been qualified by the court based on medical education or experience, for example, should not be permitted to answer the following questions. Did your grandmother have a brain tumor? She may answer, Dr. Castile said my grandmother had a brain tumor, but this response is hearsay and calls for a different objection. She is not qualified to testify as to any such medical opinion unless she has firsthand knowledge and has been qualified by the court to testify as an expert. If you spend time in your local courthouse observing hearings and trials of other people's cases, an excellent educational experience highly recommended, you will see lawyers crossing the expert line left and right. It's done all the time and all too frequently without objection. However, if you don't want unqualified experts' testimony to be heard, you must be on your toes and object. What a lay witness thinks happened is objectionable on the grounds it calls for speculation. What a lay witness was told about what happened is objectionable on the grounds it constitutes as hearsay. The only testimony a lay witness should be permitted to give, unless you want the testimony to come in any way, is what the lay witness learned through his or her five senses, i.e., what the witness saw, heard, felt, smelled, tasted. Okay? If a lay witness is called upon to testify as to matters beyond the reach of these five sensations personally, and none of the other objections, hearsay, incompetence, etc., serve the purpose, your response should be objection. This witness is not qualified as an expert. Experts can testify to hypothetical facts related to the issues of the case, but when they testify as to what they saw, heard, felt, smelled, or tasted, they are testifying as lay witness, even though they have been qualified to testify as experts. Know the distinction. Don't let an expert witness give lay testimony unless he or she personally has firsthand knowledge of the facts alleged. Don't let a lay witness give expert testimony unless he or she first submits to be examined and succeeds in being qualified as an expert. If an expert witness gives lay testimony about a fact he or she has not personally observed through the use of one of their five senses, object. If a lay witness gives expert testimony without being first qualified by the court to testify as an expert, object. If a witness is asked or begins to testify what she perceived by supernatural or psychic powers, jump to your feet at once and preserve your objection for appeal. Relevance. Unless a fact fits in some way with the issue in a case, like a bolt fits the nut it was designed for, it is said to lack relevance. If it doesn't fit, it has no place in your suit. If it doesn't fit, it can only damage your case. Any fact that's not relevant to the issue in controversy is objectionable. Every attempt to offer such a fact should trigger your objection unless the fact will tend to help your case. Relevant facts are sometimes called material facts. Such facts are those that tend to prove or disprove an issue in controversy. For example, whether Uncle Marty was a member of the Boy Scouts when he was younger and earned Eagle Scout recognition might tend to influence the court that he is trustworthy, loyal, helpful, courteous, etc. However, it is probably not relevant to the outcome of the case involving copyright infringement or personal injuries resulting from an automobile accident. If it isn't relevant and it won't help your case, object. Objection. Relevance. The past camping and wildlife experiences of this witness have no bearing whatever on the issue in this lawsuit. When the other side tries to bring in irrelevant facts, ask yourself why. There is almost always a reason, and the reason is seldom good for your side, or the other side would not be trying to get it into evidence before the court. Many times, crooked lawyers will offer irrelevant facts just to muddy the waters. They will try to make your case more complex than it needs to be. They will try to confuse the court. They will try to get the judge to consider matters that have nothing to do with the issue being tried, i.e., the issue stated in your pleadings. At the first sign of such hijacking, jump to your feet and object. Objection. Relevance. Do not let it continue. Suppose the other side calls a witness and begins. Miss Sullivan, were you present last Tuesday when my client climbed into the sycamore tree in front of his front yard? Why, yes, I was, as a matter of fact, and I saw Miss Shallasalt wandering in her backyard next door, wearing nothing but a bikini, sunglasses, and a pair of flip-flops. Was Miss Shalatot watching Mr. See No Evil climbing his sycamore tree? The lawyer against you continues. No, she was talking to her poodle and staring at me. The witness explains. What color was her bikini? The lawyer asks. Had enough? If none of this has anything to do with Mr. See No Evil and his sycamore tree, then you stand to your feet and call out in confidence. Objection. Relevance. The judge may be enjoying his imagination, but unless the lady next door or the fluffy dog have something to do with what your case is about, that testimony is irrelevant and therefore objectionable. The judge should put a stop to it, even if he secretly wants to learn more. Some lawyers do this to drag out the time so they can be paid by their client even more. Some do it to entertain the court, thinking they will thereby be seen as likable, hoping a scene of humor will win some points for their position. Others do it to distract the court from evidence that might favor your side of the argument. If testimony or other offered evidence can have no bearing on the material issue in your case, object on the grounds of relevance. It often helps to explain to the court that allowing such facts to come in will only prolong the proceedings without adding any probative benefit. Courts are protective of their docket and usually don't want to allow anything that wastes their precious time. Tell the judge the other side is offering irrelevant facts for an improper purpose to delay the proceedings or to confuse the court. You'll probably get the ruling you want, and the abusive tactics will stop. When we come back, we'll be speaking about speculation.